What's up, everybody? We are here with another episode of The Lawyer You Know to recap and catch up with everything that's happened in the ASAP Rocky trial. Before we get a verdict, I think it might happen today, the day that you are listening to this. We talked about whether we just do the Karen Reed juror interview or the ASAP Rocky recap. Well, guess what? We're going to do both. So make sure you guys hit that like button. We're going to talk about all the shenanigans. We're going to focus on the back and forth between the lawyers and how the judge handled it and what we think of that. And where we think this case ultimately ends up. We will discuss that. I want your opinion as well in the live chat and in the comments section. So let's get to it. So you know how hard it is for me to recap and update on a trial for like 4 or 5 days or a week in 1 hour, but we're going to do our best. And the way we're going to do that is just to summarize kind of a couple witnesses, talk about the closing arguments, and then focuses on the lawyer antics throughout closing arguments and the end of trial. But I want to start with Twelvyy, ASAP Twelvyy. He was calm, cool, calm, collected, had his story to tell, did what he needed to do for the defense. It was definitely a prop gun. It was self-defense. Relly was beating up on Ills. Everything he needed to say for Rocky, he said. Obviously, he's Rocky's friend. Obviously, if a juror wants to look at it that way and say, I don't believe him, I don't trust him, he's trying to help out Rocky, that's a possibility. And the prosecutors talked about that, but they just were way too aggressive, in my opinion. They were way too angry. They were way too nitpicky. When it comes to bias, it's obvious. You just get in, you're his boy. You're still his boy. You need him, whatever it may be. You can get into all of that. But the way the prosecutor cross-examined Twelvyy, to me, is indicative of the entire way this prosecutor has handled this case, which to me can be very off-putting for certain jurors. Some jurors may love him, right? If they really think Rocky's a horrible criminal and this guy's out there getting the bad guy, then fine. But for most of the vibe of this trial, it has just seemed like too much. And I want to play a few clips from their interaction, but one of the clips I'm not going to play, but that was mind-boggling to me, is Twelvyy kept saying, you feel me, you feel me, you feel me, like, you know what I mean. And, or, you know, as some people say. And this prosecutor made it a point to say, I can't feel you. You know, I can't answer these questions you're asking me. And I think to some jurors, it would be like, he was like, okay, I'll stop saying you feel me. But he made it to be like it was some bad thing that this witness was doing, when in reality, it was just like, you know. And again, you can say, stop saying, you know, whatever, but again, that's nitpicky. And as opposed to just having a conversation and getting the points out that you want to get out. We're going to show a couple different clips, like I said, of their back and forth, starting with this one, just so you can get a vibe of exactly what it's like. Sound is not working. Let's see if we can get that fixed. Yep, here we go. All right.
Yes. 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 For one, after he hit Ills, I heard him running towards me, and then that's when I juked, and I run to the side.
Wait, you just testified, sir, that Relly never tried to hit Ills at the first scene. That didn't happen until the second scene.
Okay, I'm explaining the whole situation. So to you, it might be one incident, two incidents. To everybody, it's just one incident.
No, sir. I clarified with you, and you told me you understood. We were talking about two separate incidents. I asked you specifically what happened during the first.
So the first incident.
I'm not done with my question. When I'm done, you'll know.
Objection.
I'm not done with my question. When I'm done, you'll know. I can understand that if the witness was being a complete jerk. Was this an easy witness for the prosecutor? No. Was he evading some of the questions? Yes. But he was doing it in kind of a respectful, calm, nice demeanor. He seemed like a nice guy. Of all the witnesses, this guy just seemed like a nice person, right? And it's like this prosecutor is going so hard and being a jerk, which sometimes you got to control a witness, fine. This one, I think he could have done in a normal tone of voice, and I think it would have come off better personally. I think he lost some of the good points he made in cross with his delivery. Just my opinion. You guys let me know if you agree or disagree in the chat.
I'm done on the argument of the bedroom.
Sir, please listen to my question. I'll let you know when the question is over. You were previously asked whether or not Relly hit Ills during the first incident. You said no. Do you recall that testimony?
Yes.
You are now saying that, in fact, Relly did hit Ills during the first incident, correct?
I'm not saying Relly hit Ills during the first incident. No, he did not hit Ills during the first incident.
So I want to be clear. I'll let you know when I'm talking about the second incident.
No problem.
So what I asked you is you would agree that had Relly wanted to hit either of the three of you, Ills, yourself, or the defendant, during the first incident and between the first and the second incident,
Yes.
there was nothing physically from stopping him from doing that.
If we talk about the first incident, right?
Yes.
The first incident where he put his hands on Rocky.
Yes.
Okay, so the first incident, he did put his hands on somebody.
Your Honor, can the court, I have a limited time. The witness is repeatedly, intentionally not answering my questions.
The witness is repeatedly, intentionally not answering my questions. I'm going to back it up. I think it was a very confusing question. And I think he's trying to be precise because you know how lawyers are, especially when they're cross-examining. And he goes off in front of the jury, intentionally not answering my questions. I would object to that and be like, Judge, first off, that is a speaking objection. That is not a legal objection, which he's been crying about the entire trial. Can he not do that in front of the jury? If he wants to argue that he's evading his questions, do it in closing argument. It's totally inappropriate, which all of that would have to be done at sidebar because it would also be a speaking objection.
The first and the second incident,
Yes.
there was nothing physically from stopping him from doing that.
If we talk about the first incident, right?
Yes.
The first incident where he put his hands on Rocky.
Yes.
Okay, so the first incident, he did put his hands on somebody.
Your Honor, can the court, I have a limited time. The witness is repeatedly, intentionally.
The question was like, was there anything physically stopping him? And he's like, yeah, when he put his hands on somebody. Could be the answer. I don't know. It's not a great answer, but it wasn't a great question. And then this objection.
Hands on somebody.
Your Honor, can the court, I have a limited time. The witness is repeatedly, intentionally not answering my questions.
Yeah, ask, all right, listen very carefully to the question. Just answer the question.
And letting the jury know he has limited time, which I think is also inappropriate.
Okay, ask the question again.
Isn't it true that during the first incident and between the first and second incident, that there was nothing physically preventing Relly from punching or hitting you or Hills or the defendant? That's a yes or a no question. Do you agree that that is correct?
I don't agree.
So my question is, can you tell me, you explain how strong Relly is. You explain that he's stronger than you, he's stronger than the defendant, he's stronger than Hills. So my question is, what exactly was preventing him from punching any of the three of you during the first incident or between the first and the second incident?
I don't know what exactly was stopping him aside from it was saying, trying to calm him down. It was trying to calm him down. And also, we were trying to get from where we were. So maybe because we were moving, that's the only thing that could have stopped him from hitting us because we were moving away from him.
Well, Relly did not chase after the three of you running and trying to assault.
So again, anytime he did have an answer, he would argue, and that's fine. You're allowed to do that on cross, especially if you think the witness is not being honest with you or you think that they're, evading some of your questions. That's perfectly fine. Perfectly fine. But the tone and manner in which you do it and the inappropriateness of making arguments in front of the jury is where the problem is, because he did say Relly punched Ills multiple times. They got into whether or not you could see the injuries on Ills. If the injuries with Relly would match up, fine. That's all good cross-examination. It's like, hey, we have this picture of Ills. Doesn't look like he was hurt. You said he had a bloody lip. That's good impeachment. You can do stuff like that. There are points to be had on cross of this witness, but I think the difference in their two demeanors was not as good as it could have been.
In fact, sir, you don't run until
By the way, we skipped ahead a little bit.
the defendant fires the first shot, correct?
I don't run until after Relly tries to hit me.
Listen to my question. Did you just see, sir, listen, did you see the defendant firing a shot in what we just saw? We'll play it again.
Can you play me again?
Sure. Stop.
That's the first shot.
And you start running right after that shot, correct?
Relly is already running towards me, so
Listen, motion strike is not responsive. I'm not asking what Relly did. I'm asking.
Motion strike is not responsive immediately, and he does that over and over again. If I was Taco Pina, I'd be like, and maybe Taco Pina did a little bit of this. He did. Let him answer. He did object, but maybe Taco Pina was just kind of let him give himself enough rope, basically, this prosecutor, because it doesn't sound great.
This is a yes or no question.
I did not run from the shots.
Listen to my question. I'm not asking what you ran from. Listen. Isn't it true that the timing, you do not run until after that first shot is fired? Yes or no?
Well, yes.
Okay. And it's your position, sir, that you knew it was a prop gun when it came out, correct?
Yes.
And it's your position that Relly knew it was a prop gun when it came out, correct?
Yes.
Once you agree Mr. Phillips, that what's happening in that video is not Relly attacking Ills. It's him trying to use Ills as a shield so he doesn't get shot.
No,
Let's run it, please.
Now they're going to quibble about what is shown in the video, but clearly the witness said this is what happened. The prosecutor's arguing the video shows something else. And it's a good point. The prosecutor's saying, like, why would he be hiding and why would Relly run away and do all this stuff if he knew it was a prop gun? Why didn't he just charge Rocky and be like, you know, that I'm not afraid of you. Why isn't that what happened next? Which I think is a good point. The defense is arguing even Relly knew it was a prop gun.
Stop. You agree at this point in time I can't see, at 55 seconds, Relly still has not hit Ills yet, correct?
correct.
Okay, and you would agree that right at this point in time, this is when the gun is going to come out, and that the defendant is going to advance towards where Relly and Ills are. Is
I
that
don't
correct? You don't agree with
I don't agree.
that? Watch the video, please. Stop. He is about to fire the shot. Do you agree?
You said he's about to?
Yes. Right now.
Oh, okay, so can you play it one more time?
I'm going to play through, but do you agree he's about to fire the shot?
No, can I see it?
Yeah,
Just so I
okay.
can explain it to you?
Do you agree that you have not started moving yet at that point in time, correct? You're not running yet, right? We'll play again. Go ahead. That's okay. Gun is out, and now he's about to fire. Boom. Shot happens, and you run after, correct?
I run because if you
That
want.
is not what I asked you. Motion strike is not responsive.
Stop.
He's wrong. He's trying to answer your question. You asked him why he ran, and he's explaining to you why he ran. Once again, it's just not good.
After, correct? And now he's about to fire. Boom. Shot happens, and you run after, correct?
I run because if you
That
want.
is not what I asked you. Motion strike is not responsive.
Stop. The answer is non-responsive.
Sir,
He's asking you a question.
Okay,
Wait, hold on. He's asking you a question that calls for yes or no.
I would object to that and say he can say yes or no and then explain his answer like, no, that's not why I ran.
I'm not asking you why you ran. I'm asking you, isn't it true that you do not run until after the defendant fires the shot?
that's not true.
That's not
And that's
true.
also not the question he asked.
So play it one more time, and I want you to tell me when the shot is fired. You tell me when you see that first shot fired, please.
Yes,
Okay, you tell me,
Or if it was the question he asked, it wasn't clear, I should say.
you say stop when the first shot is fired.
stop.
Okay. Do you agree, sir? You are just about to start running, but you have not started running yet. Agreed?
After the first shot,
Yes.
I'm not running. You see, he's still right there.
Okay, the first shot's fired. Keep playing.
Then you see me. That's not a shot.
So what I asked you before was, isn't it true that the first shot was fired before there was ever any contact between Relly and Ills? You said no. You would agree. When you watch this, the first shot is fired before your allegation that Relly was attacking Ills, correct?
That is not true. On the video, you can see.
Motion strike, everything after that is not true.
He should be able to explain his answer. He should be able to explain his answer. But it's a good point by the prosecutor. Shots were fired before the fight started, so it can't be self-defense. The witness wants to explain that's not what it was. There was a fight before the shot, so it was self-defense, right? That's a difference in fact, and the prosecutor can argue who's telling the truth and who's not. Do you believe the video? Do you believe witness testimony?
Isn't it true, sir, that the reason that you ran after the first shot was because you knew it was not a prop gun and you were worried that you might get shot in crossfires?
No.
And that's basically the same thought with Relly. Okay. Then Rocky's manager testified. Again, obviously going to be biased towards Rocky when you call a witness. If it's your friend, somebody connect to you, a family member, there's always that bias there. It doesn't mean you're not going to believe what they say. They can still be a very credible witness. He testified. He told Rocky it was a good idea to have the prop gun. He gave it back, I think, to where they got it from some music video or a shoot or something. And at the magazine at Rocky's house that they were trying to connect to these casings, which different ammo in it, was actually his and not Rocky's. Then Rocky was given a colloquy. Are you going to testify? He says no. There were reports that Rocky was going to testify. That would have been the most shocking thing about this trial. And there was a lot of shocking things about this trial. But I was like, what? He's going to testify? And then, of course, he didn't, which I think was the right move. Then we get to closings, which were so long and laborious and not amazing, in my opinion. Some good points were made by both sides. I liked openings better myself. But there wasn't a lot of surprise, right? This was a semi-automatic firearm. There were casings. It wasn't a prop gun. Nobody would have run if it was a prop gun. Relly's telling the truth. The witnesses for the defense are not necessarily telling the truth. Defense says it was a prop gun, not a semi-automatic firearm, therefore can't be guilty of that. You can't believe Relly. Relly's their whole case. It's all about money. It was self-defense. Believe everybody else that was there. The magazine wasn't even his. All of the arguments you would expect, but maybe some of the arguing between the lawyers that you wouldn't expect. That's going to be a big part of what we discuss now. But there was something I didn't know that Kathy Roussan posted on her Twitter that I want to take a look at now, where she compared two closing arguments done by this prosecutor, Mr. Lewin. And first, we're going to listen to his closing argument here in the Rocky case. Then we're going to listen to his closing argument in 2020 for the Durst case that he won. That's, one of his big high-profile wins, and where he uses the same argument verbatim, which is fine, and it does happen. I would say prosecutors do it more than defense attorneys because prosecutors have kind of a script they stick to more than defense attorneys, especially something like this that's not case-specific. I think it's more unusual for defense attorneys to use the same argument verbatim. Like there's 2 minutes that sound incredibly similar that we're going to listen to. And then we're going to listen to, this is the argument he decides to put into every one of his closing arguments. And I just think it's a bad argument, especially in light of what we know happened in this case. Not as much with the Durst case, because I don't know, I didn't watch that case, but thinking about what you know and how many objections and the arguments we're going to listen to after this, imagine this argument being made by the prosecutor here in this case.
This is Randy's Donuts. This is on the corner. You're looking at Randy's. This is Randy's Donuts. This is on the corner. You're looking at Randy's. This is in Inglewood, on the corner of basically Florence and Manchester and La Cienega. This is the exit from the 405. If you're coming, we're looking northbound. And 30 years ago, when I was a young deputy DA in Detroit, I used to drive from home, and I would have to take this route on the 405. And I would, every day, I would get off on the 405, and I would tell myself that if God wanted me to get a donut, he would make sure that the light that you can't see right here was red. And as you can see, God wanted me to have a lot of donuts. I ended up, most of the time, I stopped. But there came a time where it just wasn't good enough for me to take the chance on the light. So what I would do is, it's a really long straightaway, and you can see when you're getting off the freeway, you can see that light. So what I would do is literally, I would coast my car at 20 or 25 miles an hour, making sure that I hit the red, and then I could go in and I'd get that donut. And I bring this up because passing up that donut was extremely difficult for me. Very, very hard. And most days I wasn't able to do it. And I always thought that that's probably one of the hardest things that I would have to do. And then I became a trial lawyer. Then I started trying cases. Then I started trying serious cases. And I can tell you that what it takes to pass up that donut is nothing compared to what it's like when I have to sit here during a closing argument, and the defense is up, and I have to listen. And I want to get up and I want to scream, I want to yell. I can't do it.
So he's complaining about how hard it is to sit there and listen and not get up and scream and yell.
I try to do different things, try to focus on something else, try to go to a little happy place. It's really, really hard. It's especially hard when, as in this case, Mr. Prosecutor makes an argument, and I want to be clear about something.
Okay, so we have that one, and then we're going to compare it with the Durst trial, which I think was in 2020, which you'll be able to tell because everybody's in masks. And let's take a listen to that.
As many of you, probably maybe all of you have noticed, I am not the thinnest guy in the world. I tend to be, whatever prosecution team I'm on, I'm usually the heaviest. In this case, I got to be the oldest and the heaviest. And for many years, 25 years, that's been my enemy. Before it was famous, before anybody knew what Randy's Donuts was, 26 years ago, I worked in this courthouse. I worked across the street, and I used to drive on my way to work, and I'd have to get off on Manchester. Some of you who are coming from the north.
Now, it's a story that makes him likable, right? So I understand that. I get why people would like him and, think this was funny and think this was cool. So it's good to build rapport with the jury. But again, we'll just listen to it here real quick. You get the vibe. It's the same argument or same story.
Probably do the same thing on the 405. And I would play a little game with myself. I would say, okay, if the light is red at Manchester, God wants me to have a donut. But yeah, the problem with that is
I wonder if that's the jury laughing, that you can hear audibly laughing. And remember, this is a case he won. I didn't hear any of that in the Rocky case. Could have happened, but I didn't hear it audibly. The audio is much better in this case. No surprise there.
sometimes the light wasn't red. So I found out that actually it's such a long straightaway coming off the freeway that you could see it. And I would literally drive 15 miles an hour if I had to, so that when I pulled up, oh, it's red. God must really want me to have this donut. I left it up to chance. I had no part in it. It is what it is. And it was so hard, and it's still hard. Every day it's difficult to, their donuts are so good. It's so hard to pass it up. And it's really, really, really difficult. And I always thought that was kind of the toughest thing that I would have to do. And then I became a trial lawyer. And then I started doing long cases. And I realized that as hard as it is to pass up that donut, the hardest thing in the world is when the defense is giving their closing argument. And I just have to sit there. And it is so hard. I want to get up. So sometimes I'll see somebody writing. You're writing. I'll be like, wait, they're writing about that? How can they possibly be writing about that? I go, okay, calm down.
Very, very similar argument. And especially for a guy who did not sit there and listen to it, right? Who did get up and scream throughout the entire trial. And that was just mind-boggling to me. And now we're going to get into some of these arguments that were made during closing argument. I believe all of these that I'm going to show you are outside the presence of the jury, so at least that's good. But so many of them are made, and we know Taco Pina. We know his style. We know he's going to say they perjured themselves and they lied and this is extortion. And we're going to hear this back and forth and see kind of where I agree or disagree with some of the decisions that were made. But when we hear, when listening to it, it seemed like a lot and it seemed like it took forever. When I heard the numbers and even some that were reported later, how many objections were done by the prosecutor during closing arguments and how many were actually sustained, blew my mind. More than I can remember. Now, there could be other cases where there were more, but wild.
Was the second part, which had to do with, they were in essence disparaging both of us. You're right. I mean, it's not a hard question. They're saying we suborned perjury 3 times. Your Honor, that's improper. It's misconduct.
I didn't hear that.
Your Honor, it's in the record. 3 different times he said we suborned perjury. I don't know what to tell you.
Hold on. Is that it?
Your Honor,
Yes.
So I actually can't even remember how this turned out. He definitely said they put a guy up there that purged himself, or the state was okay with perjury. I don't know that he used the word suborn. I can't remember how it resulted, but he definitely did not shy away from saying prosecution witnesses perjured themselves. And you can argue that. Now, what you can't do is say the prosecutors are committing crimes. I mean, I think you should be able to argue that if you have a good faith basis that the facts point to that. But some judges won't let you say the prosecutors committed crimes or law enforcement committed crimes. But if you think they're lying, if you think they are committing crimes like perjury, you're accusing them of crimes, you better have a good faith basis to do it, which I think Taco Pina has here. And saying somebody's extorting somebody out of money, it's like the judge said he didn't say that. I kind of said I think he did say that, but you should be able to say that. If that's what you think is happening here and that's what you think the facts are pointing to, it's all up to the judge on what is proper or improper argument. But this many objections over something like this when he's calling the witness a liar, which he's allowed to do. And there's some evidence of it in this case.
It was said, then I should have stopped it, but I don't remember if it was said. You have made so far 9 objections, 6 were overruled, 3 were sustained.
So at this point, 9 objections, 6 overruled, 3 sustained. So that's 2/3 of them are being overruled. Not even 50-50, and he just keeps going. We're going to hear a higher number later, and then I heard an even higher number reported later because the closings aren't over at this point.
the problem was, I believe the first 5 I made were all overruled. The court, Your Honor, I've been in front of this court for 30 years. The court knows who I am. The court knows what my ethics are. I'm not going to sit here
So remember that because he says that a lot. The court knows who I am. The court knows what my ethics are.
and tell the court that I'm objecting when he didn't say it. He said repeatedly, we suborned perjury. Your Honor, that statement in and of itself is severe.
All right, go on. All right. Can you say, if that was said, then I'll bring it to the attention of the jury. That's an improper statement.
This is what I'm asking. Which fact need to go after our witnesses on lines? He can even misstate the evidence. What he cannot do
Mr. Tacopina can go after our witness all he wants. He can even misstate the evidence. That's what he said.
Is he cannot argue, A, why we put a witness up there. He cannot say that we suborned perjury. He cannot say that all we care about is winning. He cannot say that this is supposed to.
That's wrong. You can absolutely say all a prosecutor cares about is winning. You can absolutely do that because it's been a true, I'm not saying it's a true argument here, but it has been a true argument in the past.
The pursuit of justice, and the prosecution doesn't care about that. He has said all of those things. He needs to stick to the evidence in the case. Either he doesn't know California law or doesn't care.
Either he doesn't know California law or he doesn't care. He says that all the time as a shot at Tacopina. I disagree. You can absolutely say the prosecutors don't care about justice. If they say I can't argue that as a lawyer where I think that's exactly what's happening in the case, I would, that's an appellate issue in my opinion. Because guess what? There is such a thing as prosecutorial misconduct. I'm not saying it's happening here, but it does happen.
The prosecution doesn't care about that. He has said all of those things. He needs to stick to the evidence in the case. Either he doesn't know California law or doesn't care. And Your Honor, the court's already found, and the worst of them, and I want the court to instruct, he got out there and argued, why did you hear from Haji? The court knows, Your Honor, the court made a finding.
You're repeating yourself.
Well, will the court do something about it? Will the court instruct that that was improper argument?
Can I respond?
No, failure to call logical witnesses is permissible. You're going to have a rebuttal argument. You can address it in your rebuttal argument as to why you didn't call them.
Your Honor, this is all I'm asking, Your Honor, and I'll say it. The court knows what happened. We've had many hearings on this, et cetera. They knew the evidence. They presented it late. They had repeated orders to turn over statements. He got up and said, that's not the statement of the witness. 1054-3 is very clear. What they gave us is supposed to be the statement of the witness. When he's standing up saying, well, that's not his statement, that was his statement, that's what they had to turn over. So yeah, Your Honor, I can go back and I can go and argue the court and say, well, it's just both sides arguing. But Your Honor, there are rules for a reason, and we follow them. You have not found one instance in this case, not one, where the people did not comply to discovery, where the people did anything unethical. You've already found, you used the words, it was not inadvertent. Not inadvertent, Your Honor, means they lied and they intentionally did not give us.
I don't agree with that. That's not, it doesn't mean he lied.
Your Honor, it's not inadvertent.
Don't argue with me. I don't think it means he lied. I just said it was not inadvertent. That's the extent of my finding. It was not inadvertent. I'm not going to debate with you whether they were or were not lying. I don't believe it was a lie. I want to give the court reporter a break, and we'll take a break until 3.
I'll give, I have to just respond to this.
He wasn't going to let Tacopina respond after this guy just disparaged him for 3 minutes straight. It's like, Judge, I have to respond. Now, I think this means nothing bad is coming Tacopina's way, obviously, because if it was, the judge would let him respond.
There's a record here. One thing, I don't want to, so we can do.
You're not going to upset me.
No, I'll be quick. I don't want to give her a break. I'm sorry. But there was something that was said that was just wrong. First of all, they called our witnesses liars in their submission. So I'm calling witnesses a liar, which he admitted to being, by the way. So, I mean, if our witnesses are lying, and I put them up there, obviously, they're saying we came up with this Tottenham story. No, they're saying, I object, and they sound sworn, but that's what they're saying, number one. Number two, I can't say that they want to win.
He's saying this is semantics, suborn perjury, calling a witness a liar, that they put a witness up there that lied. It all means the same thing, and I agree with him. I agree with him.
At all costs. That's fine. I can't say that. I don't think that's an improper argument. If you say it is, I won't say it again. But the other thing, Your Honor, I didn't argue that that was his statement. I said it's not a sworn statement of Twelvyy. It's not a reported statement. I said it's a summary. I'm accurate in describing it. It is a summary. I'm just going through what I said. They disparaged our entire defense, mocked it. So I'm giving them a little bit back. I don't think I'm doing something.
You want to interrupt him? He didn't interrupt you?
Shocker, the prosecutor can't sit down like Randy's Donuts. He's just got to go get another donut, and he interrupts him again.
And the thing that he said, though, first of all, I disagree. I think one fact of relevance would be a reasonable doubt. The jury finds he's incredible on one thing of importance, like the shell casings. That's a reasonable doubt. If they still choose, it's up to them to decide what a reasonable doubt is. That could cause them to find not guilty. That's up to them. But it certainly is an argument that can be made. If they can say, no, it's not a reasonable doubt. I can make that argument. I know. But the last thing, I think Mr. Lewin's hearing failed for a second. Because the one thing, because I know he said he has an issue with it, the one thing I never said was they could have called Haji. I wouldn't do that. I didn't say that. They could check the record. What I said was they spoke to him that morning. They had a recording of Haji. That was brought out to Lou I said, if Lou was inconsistent with Haji, we referred to tape. I didn't say they could have called Haji. I can show you where I said that. I would never have said that. We could have called Haji. It wasn't going to come. So I never said that. I just simply said it was on the record.
And if it was said, Mr. Lewin can address it tomorrow. If it wasn't said, then there's nothing to address. All right, we're off the record. I want to give Kathy a break. So can you find...
Oh boy. Well, guess what? There's more. So after more objections, after more of the closing arguments, we have more arguments between these lawyers that we get to listen to now.
My objection you find annoying. It's very clear that the tone that we get when we make an objection that should be sustained is, what are you doing? That's what we said.
And he's mad about how the judge is dealing with all of his objections. He's getting annoyed. Guess what? So is everybody else. And maybe even the jury.
You specifically
Lower your voice and don't yell at me. I told you.
And this is when they yell at each other. This is outside the presence of the jury, but this is how you know. And he keeps saying, like, Judge, you know me. Judge, I practice in your courtroom all the time. Judge, you know I'm ethical. More on that later. And the judge is like, don't you yell at me. It does not seem like the judge likes him, but it seems like the prosecutor thinks the judge likes him.
you find annoying. It's very clear that the tone that we get when we make an objection that should be sustained is, what are you doing? That's what we said. You specifically
Lower your voice and don't yell at me. I told you before. I'll listen to what you say. Speak in a normal tone of voice.
Judge, we're doing the best.
It's probably what the jury is begging for too. Even jurors that are with them, they're probably like, dude, can you just be normal? Can you just make an argument in a normal tone of voice? Do you have to scream? Do you have to seem so angry and like it's everything that's happening to you is so unfair? Is that how this has to feel?
Best we can to make sure that this trial is ethically conducted. They have repeated, I've objected, you told me it's improper. You overruled repeated objections where they were saying improper things. You just said a moment ago, this is a direct quote. The prosecution accepts their witness committing perjury. I object. You respond, that's appropriate comment on the evidence. It is not appropriate comment on the evidence, Your Honor. I don't know if you didn't hear it.
I didn't hear that.
So, Judge,
What I heard, I could have been wrong, what I heard was that Mr. Tacopina was describing Relly as committing perjury.
Judge, that's a direct quote. The direct quote was, the prosecution accepts their witness committing perjury. Here's another. Relly committed extortion. There is no legal.
Do you think the jury's going to ask for what the legal description of extortion is?
Your Honor.
It means he lied for money, dude. Like, these are proper arguments. I don't get it. I don't understand why the judge is even like considering some of these, like perjury, extortion, whatever the definitions are. He lied and he's lying to get money, and they still put him up there and are continuing on this case, even though it's so obvious their main witness is lying. That's what he's saying. That's the argument he's making. And that's a proper argument. I don't know California law, so maybe they don't let you use the actual legal titles, but give me a break.
Forcing someone to pay money, that is, quote, extortion.
Your Honor.
Forget, go on to something else.
I want to make my record. I mean, you're going to do what you're going to do, but I would like to make my record. No lawyer can get up here. No lawyer can get up here and tell the jury that a crime has been committed when there is no instruction on that crime. When in fact, Your Honor, that's not the legal definition of extortion. We've objected, and the court again is basically telling me, don't worry about it, it doesn't matter. Your Honor, it does matter. After a while, when there are so many of these things, they add up. And when the court is saying, wow, what do they care about it?
No, I didn't say they don't care about it.
It's in Your Honor. It's improper argument. And the problem is.
I don't agree with you. I think using the word, quote, extortion to describe the conduct is not improper. I think it's fair comment on the evidence. You, in your rebuttal argument, you can say it wasn't extortion.
Your
You
Honor,
can address it.
Your Honor, the bigger issue, as I said, is the court repeatedly told them, do not
Tacopina's like, I got to take my jacket off for this. I got to take my jacket off for this. Starting to sweat.
connect the prosecution to committing perjury.
I'll tell you what, I didn't hear that. I'm going to ask Kathy for the exact quote. If that's what was said, I'm going to sustain your objection, and I will apologize for overruling.
Good, respond, please, on that one issue, not
Yeah.
everything else. What I said was, and I agree with what I said, but understand the context of it, okay? But I didn't say this more perfect, I didn't say it yesterday, I didn't say it today. But one thing I said, and it was very common, was the prosecution accepts their witness committing perjury. And what I mean by that is in regards to one thing, and it's indisputable, Your Honor. It was regarding Relly saying the tape was fake. The tape was fake. They got up, cross-examined Mr.
He's right. I even said it. At the time that they kept talking about that's you on the tape when they cross-examined Wale. It's like the tape, that's you, that's Relly. And the whole time they were saying it when Relly said it was fake. That he's right.
Mr. Jimmy did not ask if the tape was fake or not. Okay? They then put up transcripts of that tape recording with attributions to Mr. Efron. So that means just by that very fact, they accept the fact that he committed perjury. I'm not saying they support it, but they accept that witness committed perjury. They have
And they still put him up on the stand and ask him questions.
Your Honor,
let me finish.
Let me finish. is popping.
There's no other way for them to move forward unless they say that wasn't perjury, but it was because he said that was fake. We know it wasn't fake. It was real. That was perjury. So by then moving forward with it, arguing that the tape is important for the prosecution, that Efron said these things, that when they cross-examined Mr. Jemmy, that wasn't being a good friend to Efron because he made a tape. All that is doing is, I didn't say it's subordinate. It's different. I would never say that. I didn't say it yesterday. What it is doing.
Suborning means also committing a crime yourself, but I mean also putting up testimony you know is false is also unethical and potentially criminal. So I mean, I guess I get the difference, but at the same time, it is kind of what he's saying.
Is accepting it.
They're using perjury to convict somebody wrongfully is at the bottom line. That's what he's saying.
They didn't say, you know, we have an issue with witnesses and perjury. It's accept. I said they accepted that witnesses committing perjury. That witness committing perjury on that one issue. That's very common, Your Honor. It's not inappropriate. It wasn't the founding counsel. I didn't say Mr. Lewin. I just said they accepted, and that is true. That there's no other way around it.
It is not fair comment. It is completely unethical.
Oh,
I agree with you.
So, Your Honor,
I agree with you.
What's frightening is Mr. Tacopina just stood up here and basically defended and said, yeah, I said it, but I can say it. He doesn't know or care about the law. That is clear. And Your Honor, when it's happening.
That ain't just California law. Come on, that's everywhere. He doesn't care about the law. He keeps taking those shots. It's like,
Happened 25 times in this trial with the hiding of evidence, with the late discovery, and with repeating. You told counsel before we started, do not disparage the other side. I said yesterday, you argue what you want about witnesses. You say a witness lied. You do not disparage counsel. You repeated it yesterday. He tried to explain how he didn't make mistakes yesterday, which he did. Now he gets up and he's now admitted, yes, I made that comment. Here's why it's appropriate. Your Honor, it's not appropriate. It's completely unethical. It is immoral, and it's not professional. And again, Your Honor, the fact that he is getting up here saying, yeah, I said it, here's why, just demonstrates again, he doesn't know the law or doesn't care.
You're disparaging him, right?
I'm disparaging him because you doesn't care.
You're disparaging him, right?
I'm disparaging him because, Your Honor, he's not following the
There
rules.
is not to be any disparaging of either side.
During argument, the jury's not here. I have every right, obligation, and duty to stand up here and point out that he was being unethical. The first time the court catches me being unethical, Your Honor, the court knows. That'll be the first time. Court knows I don't do that. Court knows first argument.
I've heard enough from both of you. I missed the prosecution accepts their witness committing perjury. I don't think that's fair comment on the evidence. I think that's an improper statement. It infers that the prosecution is allowing perjury to occur. I'm going to sustain your objection, and I'm going to apologize for overruling it, and then move on. If I were the two of you, I would, just move on and not make bring it to the jury's attention. I would point out, though, I told you at the beginning of arguments that if an objection is made, I'm going to do my best to call it as I see it. You have made 17 objections. I have overruled 12. I have sustained 5. I'm doing the best.
now he's even worse than 1/3. 17 objections. He's only sustained 5. That's annoying. That's borderline unethical. That's an appellate issue. If Rocky does lose, that's an appellate issue.
I can. I will continue to do the best I can, and that's all I can say.
I just want to put on the record that, these remarks about being unethical, I just about had it with him. This from a lawyer who, and I just.
He said, he keeps calling me unethical. I've just about had it from him. And this is from a lawyer. And here's the part that's the real kicker.
These remarks about being unethical, I just about had it with him. This from a lawyer who, and I just stated yesterday on it, this from a lawyer who asked in front of a jury for a stipulation that a shooting range was not in California, when either he knew it was in California or had no idea that it was in California. Okay? So he literally asked for a stipulation in front of a jury that he knew was not true or didn't know if it was true. And that's unethical. That's unethical. And this is a guy who, the Ninth Circuit just said lied to a jury in the Branford case.
Your Honor.
This is a guy who the Ninth Circuit just said lied to the jury in the Branford case. Oh, and that's true. That is true. He has been found to say something that he knew or should have known was untrue to a jury by an appellate court. I mean, that's a zinger. And this is after this is the guy who keeps saying, court judge, you know me, you know I'm going to tell the truth, you know I'm ethical, you know I would never say something that's untrue. It's like, yikes. If I had that in my background, I probably would not get up on that soapbox about as many times as he has, which isn't great. And then he threatens Tacopina after he says that.
And this is a guy who of the Ninth Circuit just said lied to a jury in the Brantford case.
Your Honor,
So I don't want to hear about him.
one more thing out of him, and we air everything that's happened in this case.
One more thing out of him, and we air everything that's happened in this case. That's what he threatens Taco Pina with, and Taco Pina goes, woo!
Who of the Ninth Circuit just said lied to a jury in the Brantford case.
Your Honor,
So I don't want to hear about him.
one more thing out of him, and we air everything that's happened in this case, which the court's aware of.
Stop.
He might want to stop.
I'm so threatened.
You should be, Joe.
Oh,
Let's take a break.
You should be.
don't tell the courts ever told me I was a liar.
So I do want to play this other clip. I think we get a little bit more of the under the breath argument between these two lawyers, but he's like, you should be scared, Joe. You should be scared. And maybe he's got something, and maybe he's right. I don't know. But there were other reports. Let's listen to this last clip before I read the last report. So this is the last clip I have with these lawyers fighting with each other. Let's see here. All right, let's take, this is kind of the same as the end of that argument, but we can hear a little bit more of what's caught quietly. So I wanted to listen to it and just kind of discuss it.
That he knew was not true or didn't know if it was true. And that's unethical. That's unethical. And this is a guy who of the Ninth Circuit just said lied to a jury in the Brantford case.
Your Honor,
So I don't want to hear about him.
one more thing out of him, and we air everything that's happened in this case, which the court's aware of.
Stop.
He might want to stop.
I'm so threatened.
You should be, Joe.
Oh,
Let's take a break.
You should be.
don't tell the courts ever told me I was a liar.
Hey.
Oh, yeah, I'm so scared of you.
Stop it.
Stipulation.
Oh, I'm so scared of you. Stop it. Knock it off. I mean, this judge, he's just lost control of the courtroom. There's other reports from Black Letter Law on Twitter that says, after contentious discussions with the judge about the prosecution supporting perjury, here's what happened. Taco Pina raised his voice, brought up the Brantford case. Lewin said one more word out of him. In this case, the court knows about it. Your time is coming, buddy. Oh, I'm so scared of you. You know everyone's worried about you. Lewin said, any idea when you'll be finished? And Taco Pina said, whenever the F I want. And Lewin said, the steroids are really affecting you. Taco Pina said, you're hunched like a hunchback. And the judge notes that Lewin had 17 objections. So apparently off mic and off camera, that's what was said. And it's just fallen out of even being something that can represent what should happen in court. There's a dude's life on the line. There is an accusation that a very serious crime and violent crime has been committed. It is just not good. It's completely off the rails. And I think a trial like this with a jury watching usually is the best kind of trial to end in a not guilty verdict. That would be my guess at this point. Is closing arguments are done. There's just too much reasonable doubt. The lack of credibility of Relly to me is paramount. It is the most important thing. I don't know what I can believe. I don't know what I can't believe. There's no way I think the state proved this case beyond a reasonable doubt. Do I believe it was a prop gun? Not really. I don't know, but that's not part of the case. The defense does not have to prove to me this is a prop gun beyond a reasonable doubt. The state has to prove to me that a real semi-automatic firearm was used to assault Relly. And I just am not buying that beyond a reasonable doubt. Do I think it's possible that happened? Yes. I think that is absolutely possible that that's exactly what happened. But there's way too many holes with the investigations, with what the cops found, with what Relly has said, and with people getting up there on the stand and under oath saying it was a prop gun. So I think it's possible that it was a prop gun. I don't know. That's the point. And because of the burden of proof, it's with the state. That's where I'm at. But I really want to know what you guys think. Do you think this is going to end up with a guilty or not guilty verdict, and why? Please let me know in the comment section. If you're still following it, maybe we'll do a live reaction to the verdict or a post reaction to the verdict. If there's some press conferences, which I bet there will be by Taco Pina. Let me know if you guys want that kind of content. There were some questions throughout, not a ton, but if there's a lot more interest growing in this case coming down to the verdict, just let me know by liking the video and leaving a comment in the comment section. Thanks for hanging with me. Was able to knock both out. Got to as much of as I could in this recap. Hopefully you guys enjoyed it. Till the next time, I'm out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, the Lawyer You Know.